Thank you, Mr. Chairman. I appreciate all of you being here. It's been very interesting, and I want to go with what Professor Frost was just talking about, because as you sit here and we're talking, and I think of the Judiciary Act of 1789, where we did Congress, set a precedent of getting in and basically setting up a court from a very, I would say, some fine-tuning, some administrative issues and setting it up. And you get to the point of separation of powers. What is, and we talk about this all the time anyway, at least in my little group in Congress we do. Where do we set these boundaries? What do you see as the legitimate check on the independent judiciary from this branch? And that's all of you, be as brief as you can, but as extensive as you can, knowing that I might have some follow-up questions for you.
Well, I think the array is pretty significant. The 100-ton gun is the power to impeach and remove judges. There is the power over the budget to make sure they're not engaging in wasteful spending. There's the power to establish lower courts, by implication disestablish lower courts, and regulate their operations fairly extensively, their practice, their procedure, their administration.
Jurisdiction.
What?
And their jurisdiction.
Yes, I mean, and their administrate jurisdiction, yes, and I think that there's also the power of the necessary and proper power to make sure that they have the framework necessary to create the Judicial Conference of the United States, to create the administrative office, to create the Federal Judicial Center where Russell used to work. And so I think that that's kind of the array, and at the Supreme Court level to manage its jurisdiction as well.
One other thing I'd add, that's the power of oversight. It seems to me Congress has the authority to oversee the operation of the federal courts, and it should exercise it. It's good for the federal courts to have someone looking at their operations. That's important as well.
And recent history bears that out, right? You have the Ethics in Government Act of 1978 that applied to the justices in terms of disclosure, the Ethics Reform Act of 1989. So every 20 or 30 years of the history of the country, there's been some form of Judiciary Act, which in most cases applies both to the justices and the lower court judges.
I agree with everything that my fellow panelists said. I just want to add, I think this kind of legislation should not be viewed as diminishing or undermining the courts, but as strengthening it. And that's one of Congress's roles, to protect and strengthen the courts.
So when we look at Article 3, Section 1, and we talk about, and it says specifically that the justices shall hold their offices during good behavior, right? It's not lifetime, but it's good behavior. And expand on what you've been talking about this morning on the authority of the legislative branch to basically monitor or check bad behavior. And we just talked about some of that, but if you would, and we're taking this right into the ethics of the Supreme Court justices in particular.
I mean, I think there is the argument of there being a gap between the high crimes and misdemeanors that are subject to removal for impeachment and less than good behavior. That is subject potentially to regulation. And the Judicial Conduct and Disability Act of 1980 tries to fill that gap by creating a disciplinary mechanism within the federal judiciary, which I think is and has been deemed constitutional. For reasons that Mr. Wheeler gave, I am on board with the notion that it's a bad idea to extend that to the Supreme Court, but I think that is that middle ground that is open to regulation by the Congress.
Wheeler.
I really have nothing to add to that. I'll yield back my time.
All right, so we're good there. All right, and I appreciate you being here, and look forward to the rest of this hearing.